Okay. Are you connecting me through to a QI?
That's what I'm getting right now, is seeing who is on call, and I'm going to get you right to them. Give me 1 second, sir. I'm going to put you on a quick hold. So 1 moment, please. Your rank?
Ship's master.
Okay, thank you. Ship's name?
El Faro.
Spell that? E-L?
Oh, man. The clock is ticking. Can I please speak with a QI?
Got it, sir. Again, I'm going to give you reach right now. 1 moment, please. Hi, good morning. My name is Just give me 1 moment. I'm going to try to connect you now, okay? Mr. Davidson?
Okay.
Okay, 1 moment, please. Hi, thank you for waiting.
God.
Just really briefly, what is the problem you're having?
I have a marine emergency, and I would like to speak to a QI. We had a hull breach. A scuttle blew open during a storm. We have water down in 3 holes with a heavy lift. We've lost the main propulsion unit. The engineers cannot get it going. Can I speak with a QI, please?
Yes, thank you so much. 1 moment.
Old and archaic. That's maritime law in a nutshell. The container ship El Faro sank on October 1st, 2015, with all 33 crew members lost tragically. And less than 30 days later, Tote Maritime, the company that owned the El Faro, sued the victims and their families. Yes, you heard that right. The corporation immediately sued the victims. My goal is to become the best high-stakes litigator, and to do that, it's important to study the influential cases from the past and learn from them. In this new series, I've partnered with Sam from Brick and Mortar. We'll go in depth into the legal aftermath of these high-stakes maritime cases. We'll discuss how NTSB reports can factor into litigation and much more. Because your justice matters.
The container ship El Faro was, by 2015, for lack of a better description, tired. Part of Tote Maritime's Ponce-class fleet, only 2 remained. Sisters El Yunque and El Faro. El Moro had been retired in 2013. Launched in 1975 as trailer ships, they'd all seen multiple major conversions throughout their lives. Originally owned by what was known as Totem Ocean Trailer Express out of Tacoma, Washington, essentially reorganized and became what is known in modern times as Tote Maritime. The company's motto? On time, every time. In the time period, though, it was much more common to haul a main deck full of semi-trailers. This paled in comparison to the design and stability changes required to accommodate a deck stacked with modern shipping containers. The conversion in 2006 to container hauler was in addition to what El Faro was already capable of, hauling roll-on, roll-off cargo below decks. And by this time, Tote Maritime was based out of Jacksonville, Florida. Vehicles and trailers rolled in through permanent openings along Deck 2, a weather deck, open to the elements with ramps leading below and ladders for personnel movement. Scuttles, or hatches atop these ladders, intended only to be open briefly enough for personnel use. Notably slow to recover from any rolling conditions, even when simply rolling to one side under their own rudder commands, stability was always an issue for the Ponce fleet, especially now as container ships. A tote manager at Jacksonville Port noting, quote, the greatest list he'd ever observed during loading. A photo was taken of this incident when the ship was being loaded for the actual accident voyage on September 29, 2015. Reports state the list was corrected and cargo shifted accordingly. However, newer, more purpose-built vessels were scheduled to soon take over Tote's weekly Jacksonville to San Juan routes crucial to the island of Puerto Rico's supply chain, especially in food distribution from mainland U.S. Important to note though, after its conversion to container hauler in 2006, El Faro was laid up for roughly 6 years until 2014, reportedly entering a state of serious disrepair, brought out of retirement to then replace El Moro. These upcoming modern ships of totes, though, brought about several issues. According to investigators, the old fleet had earned a reputation with its command structure as rust buckets. The upcoming Marlin-class vessels caused much turmoil amongst those, quote, still stuck manning the old fleet. In 2015 alone, chief mates caught sleeping on the bridge while underway, lax training and maintenance practices, safety equipment and drills severely lacking. TOT's priority shift to the new fleet also meant onshore office and engineering personnel had their focus shifted away from the Ponce vessels as well. According to the Coast Guard, this even included the old fleet's Director of Safety and Services. El Faro was also in the middle of retrofits, TOT planning to return it to their Alaska routes at some point. There were some light tasks, like electrical work, that could be performed while underway. Riding along to perform these tasks was a crew of 5 Polish contractors and their supervisor, a TOT engineer. Captain Michael Davidson, 53 years old and a man of commanding presence, according to some colleagues was known as a stateroom captain, commanding from arm's length and not interested in the minute details of ship operation. Climbing the ranks quickly, by the time of El Faro's incident voyage, Davidson was still relatively new to the position. He'd been vying for another promotion too, to captain the new Marlin-class ships. But TOT halted this in the summer of 2015, citing he'd been negligent in some of El Faro's critical steel repairs, neglecting disciplinary actions with officers caught repeatedly and blatantly sleeping on duty, and that he had personality conflicts amongst teammates in the past. The NTSB noting he wasn't made aware of TOT's decision yet, and quote, "If the captain thought his performance on this trip would be a deciding factor, it might have affected his decision-making. He might have been more risk-tolerant." At first, Joaquin was just a tropical storm, projected to turn north. El Faro's crew had routes planned they'd used successfully in the past to, quote, "duck into" throughout the Bahamas anyway, should the storm become an issue. The second mate even texting the captain her concerns, discussing alternate route preparation prior to shoving off. The captain insisted they run straight through though, indifferent to the storm and the second mate's concerns. Even overheard stating on the bridge that evening, "We're just going to go out and shoot under it." Their arrival estimated for Friday, October 2nd, a 4-day journey. Getting underway Tuesday evening, September 29th, there were 33 souls on board between the 27 El Faro crew, 5 Polish contract workers, and TOT engineer. As predicted, weather authorities announced Joaquin's projected course change by Tuesday night though, to head further southwest, and expected to loiter while reaching hurricane strength. Several bridge crew attempted to raise this issue with the captain on multiple occasions on Wednesday. The captain, however, was utilizing a single third-party weather program he preferred, which was providing forecasts and projections outdated by hours, possibly even days. He approved a slight deviation, but this wasn't a course change that actually brought the vessel near safe harbor. Retiring to his quarters Wednesday night, indifferent to the situation, and standing firm that his relief keep them on course, he'd remain there until the following morning. A widow of one of the Polish riding crew workers later quoted as saying, "After he boarded the boat, he was in despair about the conditions there. He told me it was dirty and hot because the air conditioning was not working. He was happy that he had managed to get a cabin with a fan. He also said he had never seen or worked on a hulk like this. While he was working, rust was falling into his eyes. He didn't go through any training about boat safety, such as an evacuation drill. He wasn't telling me about weather conditions because he knew I was worrying a lot. During his voyage, there were 2 tropical storms I found out about only after they were over. He was trying to calm me down, telling me not to worry because the captain was prudent, and in such situations would always steer in between islands, which was safer." When the captain awoke Thursday morning, they were nearing the eye of Hurricane Joaquin, soon to be Category 4. Still neither concerned nor taking on board the input of his fellow officers, Captain Davidson was overheard joking around about how he, quote, "was sleeping like a baby," telling sarcastic anecdotes about his previous jobs in Alaska waters being so much worse, making remarks about the storm and how they were, quote, "on the backside of it, only going to get better from here." With initial downflooding caused by a scuttle left open on 2 deck, vehicles on deck 4 floated and broke loose, impacting emergency fire suppression piping, water then flowing freely into the bottommost holds. This heavy list to starboard, though, was also submerging the open scuttle, which the crew eventually discovered to be one of the issues. But it wasn't just the open ladder hatch causing the starboard list. They'd sustained hurricane-force winds to their port side for hours, and trailers were also thought to have broken loose on 2 deck. Speed had decreased now to about 4 knots, and the engine room was struggling to keep propulsion running. El Faro had been pushing at maximum for hours. The captain overheard saying, "The only way to do a counter on this is to fill the port side ramp tank up." Referring to the aft deep tanks, the captain wanted ballast water transferred over to the port side. He'd also have them change course, first to put the bow into the wind, then turned all the way north to a heading of 350 degrees to put the wind on their starboard side. He still hadn't recognized the situation as an emergency though, making no calls yet to muster and no preparations to abandon.
Cam Davidson, Thursday morning, 0700. We have a navigational incident. I'll keep it short. A scuttle popped open on 2 deck, and we were having some free communication of water go down the 3 holes. Had a pretty good list. I want to just touch it, contact you verbally here. Everybody's safe, but I want to talk to you.
This voicemail was left with El Faro's designated person ashore, a tote contact, but he was out of office. The message eventually relayed to the U.S. Coast Guard by the tote employee, the voicemail clearly stating just a pretty good list and everybody's safe, which, coming from a captain of Davidson Station, would be hard to read into as actually being an emergency. And by this point, the captain had allowed no other forms of distress calls or messages sent from El Faro either. The severe list to port exposed yet another critical flaw in both maintenance and design on board this older ship. Oil pumps lost suction and couldn't recover. The NTSB stating, because the suction for the lubricating oil service pump was located in the starboard aft section of the pump, a port list with a forward trim would be the worst case scenario for exposing the suction bell mouth, which could result in a loss of lubricating oil to the main engine. The vessel soon lost propulsion and, with ballast water now fully transferred to port, a process that takes some time, without propulsion in such heavy weather, with free communication of water below allowing bottom holds to fill further, there was no way to bring the vessel about again, no hope to get the list righted, or back to their starboard side. This would be difficult enough in calm conditions, but they were deep inside of a now Category 4 hurricane, roughly 400 miles wide. With no working power plant, outdated near useless safety equipment, lacking emergency training, and no hope for Coast Guard rescue, they were now completely at the mercy of Hurricane Joaquin. The second mate had prepared an emergency message to send via their satellite terminal at about 6:30 a.m., the captain not allowing her to transmit the distress message until 7:12 a.m. And it wasn't until 7:26 a.m. that Captain Davidson finally gave in and rang El Faro's general alarm, calling far too late for those on board to abandon. The El Faro was lost at about 7:39 a.m., with all souls aboard Thursday morning, October 1st, 2015. On Brick and Mortar, we explore these events in detail and take deep dives into their safety lessons learned and the engineering, technical, and human error aspects behind them, because your safety matters. I'm so excited to partner with attorney Tom, so the stories can now continue from there as he expands on the legal aftermath, on fighting for the people when these things happen, and explain in depth why your justice matters.
On October 30th, just 29 days later, Tote Maritime sued the victims of the El Faro tragedy in the company's headquarters state of Florida. Victims and their families are sued quite often in maritime lawsuits, and these lawsuits are filed immediately because of the high-powered legal teams maritime corporations can employ. This forces families of the deceased to take legal action in response quickly. Obviously, this can add unnecessary pressure to an already emotional and stressful time. Generally speaking, in a non-maritime wrongful death lawsuit, say for instance a refinery explosion, the victims would file a lawsuit against the negligent parties. However, In most maritime lawsuits involving catastrophic injury and wrongful death, the framework of this litigation is completely flipped, and it's unique to the maritime world. Allow me to introduce the Limitations of Liability Act. Passed in 1851, the Limitations of Liability Act was initially created to encourage investment in the shipping industry by providing financial protection to ship owners, or limiting their monetary liability in the event of a catastrophe. At the time, this protection was crucial for the growth of maritime commerce in the U.S. The Act protects ship owners after maritime incidents by limiting the amount they can be sued for to the post-incident value of the vessel plus its cargo. Meaning, even if a ship owner is found liable for an incident, the amount they can be sued for is capped at the value of the ship and its cargo after the incident. And ship owners are notorious for providing the absolute minimum valuation possible. While the Act may have served its original purpose in the 19th century, its continued existence can lead to inadequate compensation for the losses suffered by injured mariners or their families. In the modern world, ships are often worth far less than the potential claims arising from a major incident, particularly when it comes to personal injury or wrongful death. For example, let's say a mariner dies due to the negligent actions of their employer. The stricken vessel is given a post-incident value of $100,000 with no cargo. Then the vessel owner successfully invokes the Limitations of Liability Act. The most that mariner's family or estate can recover is $100,000. Now, let's use that same example with 2 deceased mariners. Now imagine 4 deceased mariners, 10 deceased mariners. No matter how much damage is caused, the vessel owner's exposure will be capped at $100,000 if they can successfully invoke a limitations action. This can lead the victims to fight amongst themselves in splitting up this small sum of money. A famous example of a ship owner using this act following a mass casualty event is actually the Titanic. The owner of the Titanic filed a limitations of liability action in which the value of the Titanic was estimated at less than $100,000, $300 for the 14 remaining lifeboats, and $92,000 for the ship's earnings. For the families of the 1,517 people who were killed and the 711 survivors, this would have equated to just about $41 each. And the law requires ship owners to file their limitations action within 6 months of the incident, although most are filed immediately in hopes of catching survivors or families of the deceased off guard. In the case of the Faro, Tote claimed the value of the ship was $0. Yes, $0. They claimed that the value of the cargo was just over $2 million, and its death claim fund, which is essentially an insurance policy they're required to carry, usually tied to the gross of the ship, was just over $13,236,000, adding up to a total of $15.3 million. When a limitations of liability action is filed, the court stops all claims against the ship owner and consolidates them into one federal proceeding, now contingent upon the outcome of the limitations action. In response, at least 52 claims were made to Tote's limitation filing. And keep in mind, these ships are a crucial lifeline for the island of Puerto Rico, delivering cars, transport trucks, retail goods, and fresh foods for grocery stores. So these not only represent wrongful death claims of the lost crew, but also property claims for the parties who lost cargo the Faro was transporting. Now, victims can attempt to prevent a vessel owner's ability to hide behind the Limitations of Liability Act. The issue of whether or not the Limitations of Liability Act is applicable is a trial within a trial. A limitations proceeding is essentially a separate legal proceeding that occurs alongside the main litigation, requiring its very own evidentiary presentation and legal arguments. In certain circumstances, a limitations of liability action can be defeated. One way to defeat a limitations action is by demonstrating that a ship owner had privity or knowledge of the unseaworthy conditions or acts of negligence that led to the incident, as limitations may not apply when the ship owner had actual knowledge. Another approach is to argue that the vessel was unseaworthy at the time of the incident, showing that it was unfit for its intended purpose or reasonably safe operation. Additionally, a limitations action may not apply if the victim can prove that the shipowner engaged in willful misconduct, displaying intentional or reckless behavior that disregarded the safety of others. Now, I can speak from personal experience because my firm, Kirker Garcia, has handled maritime injury cases where a corporation has invoked a limitations action. At this point in time, the legal team involved needs to answer some crucial, albeit technical questions, and this hints at possible future video topics. But for the sake of time, we're going to focus on the primary arguments made in the case of El Faro. At this point, there are two distinct outcomes. Either TOTE will successfully invoke a limitations of liability action, the court allowing a limitation fund to be established, and that fund will reflect the maximum amount TOTE could be sued for. Or the victims could successfully argue that the limitations action should not apply. They may challenge TOTE's filing by presenting evidence that the shipowner had knowledge of the unseaworthy conditions or negligent acts that led to the event. If the court finds that the owner is not entitled to hide behind the Limitations of Liability Act, the victims can pursue their claims without a limited dollar amount looming over their heads. Some of the most notable arguments that the El Faro victims raised to defeat TOTE's limitation action include unseaworthiness, privity and knowledge, and willful misconduct. To prove these arguments, injured mariners and their families need to gather evidence independently and demonstrate it. The evidence might include inspection reports or maintenance records that show the vessel was not adequately maintained or that the necessary repairs were ignored. Testimonies from crew members, experts, or other witnesses who can attest to the vessel's unsafe conditions or practices. Photographs or videos that document the unseaworthy conditions, faulty equipment, or other hazards on the vessel. Even internal communication, such as emails or memos, that reveal that the ship owner's knowledge of the unseaworthiness conditions or their failure to address them.
With the El Faro now at 15,400 feet deep on the bottom of the Atlantic, investigators used the still operational sister ship El Yunque to compare findings, very similar in its design, operation, and maintenance to El Faro. Authorities found trailers on deck 2 not anchored down properly, cars below decks not lashed down properly, and couldn't have been even if the crew tried. The deck didn't contain enough D-ring anchors to the point where a length of chain was ran between what few there were, and the cars attached loosely to those lengths of chain. Louvered air supply openings that led all the way down to the bottom holds. Investigators found out crews regularly left these open, even in heavy weather, and on El Yunque, some were so rusted out, they were no longer watertight. More openings that could have initiated downflooding once El Faro's list was great enough. The El Yunque coming under Coast Guard inspection and audit soon after, which mandated TOTE remedy these cargo hold ventilation ducts within 30 days, due to excessive corrosion. TOTE soon transferred El Yunque to Seattle for that planned conversion back to Alaska service. It was audited again by the Coast Guard, finding even more deficiencies and half measures. Uncorrected wastage, even more corrosion in those same ventilation ducts to the cargo holds. TOTE gave up and scrapped El Yunque by August of 2016. In the sinking of El Faro, from the NTSB's probable cause, quote, "The NTSB determines that the probable cause of the sinking of El Faro and the subsequent loss of life was the captain's insufficient action to avoid Hurricane Joaquin, his failure to use the most current weather information, and his late decision to muster the crew. Contributing to the sinking was ineffective bridge resource management on board El Faro, which included the captain's failure to adequately consider officers' suggestions. Also contributing to the sinking was the inadequacy of both TOTE's oversight and its safety management system. Further contributing factors were flooding in a cargo hold from an undetected open watertight scuttle and damaged seawater piping, loss of propulsion due to low lube oil pressure to the main engine resulting from a sustained list, and subsequent downflooding through unsecured ventilation closures to the cargo holds. Also contributing to the loss of the vessel was the lack of an approved damage control plan that would have assisted the crew in recognizing the severity of the vessel's condition and in responding to the emergency. Contributing to the loss of life was the lack of appropriate survival craft for the conditions.
It is important to note that according to 49 U.S.C. Section 1154B, NTSB reports and findings may not be admitted as evidence or used in any lawsuit or action for damages resulting from a transportation incident. The purpose of this rule is to encourage open and honest communication during the investigation process and to prevent NTSB from being influenced by potential litigation. However, this restriction does not mean the information contained in an NTSB report is entirely off limits for maritime lawsuits. The facts uncovered during the investigation can be independently established and used as evidence as long as they are presented through admissible means, such as witness testimony or expert analysis. I think there is sufficient evidence to believe that TOTE's limitations of liability action could have been thrown out. The El Faro was old, went through numerous major conversions, was notorious for its poor maintenance, and spent 2006 to 2014 inactive. It even appears that the crew, and by extension TOTE, were well aware of the El Faro's deteriorating condition, commonly referring to it and the rest of the Ponce class as rust buckets. TOTE also seemed to divert critical resources away from the El Faro to focus on their shiny new Marlin-class fleet, likely neglecting infrastructure and repairs needed to keep old vessels safe. They even failed to provide safety training. Further, the vessel lacked adequate safety equipment and lifeboats. And in addition to all of that, Captain Davidson's desire to seek a promotion may have contributed to his refusal to seek safe harbor, instead taking the El Faro directly through the path of Hurricane Joaquin and refusing to signal that the crew of the El Faro was in danger until it was too late. TOTE was aware that Captain Davidson had serious performance infractions in the past, yet was still trying to obtain a promotion to the Marlin-class fleet. This pressure to perform may have affected his decision-making, deciding against a route of safe harbor that would have only added a couple of days to their voyage. After all, TOTE's motto was, "On time, every time." All of this evidence suggests that TOTE had actual, or at the very least constructive knowledge of the unseaworthy condition of the El Faro and other dangerous conditions they created by failing to take appropriate preventative measures. There was a very real possibility the limitations action was at risk of being thrown out. While all 33 wrongful death claims were settled confidentially before a ruling on whether or not TOTE could hide behind the limitations action, there was one claim in which we do have data regarding a fee dispute amongst family members of the lost El Faro mariner. In that case, the limited settlement data revealed that the survivorship claim was settled for $500,000. A survivorship claim, also known as a survival action or survival claim, is a legal action that allows the family or estate of a deceased person to recover damages for pain and suffering, lost wages, and any other losses the deceased person may have experienced between the time of injury and their death. The survivorship claim for the El Faro would have referred to the mental anguish, pain, and suffering the mariners endured while their ship was going down, knowing no one was coming to save them. Survivorship claims are separate from wrongful death claims. A wrongful death claim seeks to compensate the deceased person's family for their losses resulting from the death. All of the victims or estates in the case of the El Faro likely had both a survivorship claim and a wrongful death claim. So if we assume that all 32 mariners, excluding the estate of Captain Davidson, settled just their survivorship claim alone for $500,000 each. That puts Tote's total liability at $16 million before we even address their wrongful death claims, which likely carried higher values. It's safe to assume that Tote recognized the very real possibility of losing their limitations action. And even if Tote could successfully invoke the limitations action, the victims also have the ability to contest the value of the ship and its cargo by disputing the shipowner's valuation. After all, the U.S. Coast Guard placed a valuation estimate in losses of $40 million on the ship and $65 million on the cargo. The NTSB estimate for the ship's loss was $36 million, and clearly Tote's valuation of $0 for the vessel and $2 million for its cargo wouldn't be seen as reasonable. As such, I'm comfortable assuming that Tote ended up paying much more than their initial $15 million cap that they tried to implement. And while it's likely that each victim's estate settled their claim for millions of dollars in the case of the El Faro, I would argue that the potential cap looming over victims' heads contributed to an unequitable and unnecessary devaluing of those lost lives. I think you could make an argument that a company as reckless and negligent as Tote deserved to pay every penny they had to these victims. And unfortunately, in many cases, maritime injury victims aren't lucky enough to begin to fight over any significant amount of money because of the Limitations of Liability Act. While the loss of life is tragic, it wasn't in vain, because the investigations and the victims' families' pursuit to uncover the truth through substantial litigation efforts did lead to several safety recommendations aimed at preventing similar maritime disasters in the future. Some of the most significant safety changes made after the El Faro sinking include enhanced vessel inspections. The U.S. Coast Guard overhauled its inspection program for aging vessels, focusing on more rigorous oversight and inspections to ensure vessel safety. This included an emphasis on examining the structural soundness and seaworthiness of older ships. Improved storm tracking and avoidance. The Coast Guard and NTSB recommended better training for mariners in the use of weather forecast and storm tracking information. They emphasized the need for clear protocols requiring ship captains to avoid severe weather conditions and to not underestimate the risks posed by hurricanes and tropical storms. Stronger safety equipment regulations. The recommendations also include calls for more stringent regulations related to safety equipment on board ships, particularly lifeboats. This was in response to finding that the El Faro's open-style lifeboats were not adequate to protect the crew from the hurricane conditions they faced. Better safety management. The authorities stressed the need for stronger safety management systems on board ships with a focus on risk management, safety culture, and emergency response preparedness. This includes the establishment of safety management certifications for vessel operators. Personal locator beacons. Personal locator beacons emit a distress signal that can be detected by international search and rescue satellites, providing a precise location for the individual in distress. These devices have been increasingly used in a variety of contexts, including aviation, hiking, and maritime activities. For seafarers, having a PLB could increase their chances of survival in the case of an emergency by expediting the rescue process. While the El Faro investigation did not specifically lead to authorities mandating the use of personal GPS trackers, the incident has contributed to the ongoing conversation about crew safety and the potential value of such devices in saving lives. PLBs are now much more common in the maritime world, and the U.S. Coast Guard, NTSB, and even SAM at Brick and Mortar are huge proponents for PLBs. The last thing I'll leave you with is this. I see it all too often. Corporations putting profits over people's lives. And when tragedy strikes, they hide behind every nook and cranny provided for them by the law to skirt responsibility. Had these victims not taken immediate legal action and contested the limitations of liability filing, had they not persevered, Tote Maritime might have gotten off easy. Thanks for watching, and remember, your justice matters.